on Remedies, and we are excited to be here in this virtual platform. Not too excited, but we're at least glad to have some wonderful content today and be able to have conversation with our Remedies section and anyone else who might be listening along. We will be monitoring the chat, and that's myself, Caprice Roberts. I'm a visiting professor at George Washington University Law School, and also John Golden from Texas. Both of us will be monitoring the questions, seeing if you have anything. And we have our panelists who are each going to be speaking, not exactly in the order in the program, but hopefully you've taken a look at the program to see their extensive bios with wonderful credentials that they bring to us today. I'm going to give very brief introduction remarks so that we can get right into it. And our first speaker is going to be Owen Odell. But before I do that, I just want to say that ordinarily we would have a Remedies section meeting right now during the session at the end, and AALS has asked us not to do that. So we've already done it by email, which means I am the outgoing chair. I will run this session, and then Sam Bray of Notre Dame will become the new chair as soon as this meeting is over. And we also have a chair-elect, which is John Golden, and many other new members of the executive board, so of the committee. And anybody who wants to also join the section, you can still do that through AALS. So all of that was by email. If you're not getting those emails, please let me know and or sign up on AALS. One thing we did send through the emails was our award, which we gave a section award for a lifetime achievement for scholarly achievement in Remedies. And this went to Doug Rendelman, and claps for that. He's a professor at Washington Lee. Most of you know him well. He's mentored so many. He's taught for 50 years. And this past spring, he began sort of the retirement process. He's still teaching, he's still writing, and doing so many fabulous things that I put in the Remedies email, the details about why the section selected him. And he wrote and wanted to say today how much he is grateful and thankful to the whole section for thinking of him and honoring him, because we have so many giants in this field. So anyway, he says thank you. We couldn't get him part of the video today, but he is in the audience, and so please be thinking of him until we get together the next time and celebrate him and so many others. Today, we have the panel of experts, as I've mentioned, as well as a call for paper winner, which will be our last speaker, Tracy Thomas. But let me tell you a little bit about our panel. Of course, last year's panel, we were on a hot topic as well, which was basically voting rights and election time. And so that's we've got many of our section members working on that right now, literally through what's happening. Many of you up late thinking about those remedies and details. And this year we're doing Remedies in Uncertain Times, which of course gives us an opportunity to think about the ways in which remedies must borrow from equity, also come up against law, and we're going to see that in the talks today. And they cut across many different causes of action. Of course, intellectual property being one of our great camaraderie areas, and we have that section co-sponsoring with us today. And so some of the topics we'll touch on IP, but then we'll also get into shadow docket remedies, which go much broader than that. And I think we're going to have an exciting opportunity for discussion. So let's just get right into it. I've mentioned John Golden as a co-moderator with me. He may well interject some questions as we go along, but we're planning on remarks from each speaker and then having questions at the end. And as I said, we're going to vary the order a little bit because Owen Odell has come to us from Trinity College Dublin. He is bringing an international perspective, and we didn't want you to have to wait to see his PowerPoint slides that he's prepared so diligently. So we're going to start with Owen, and then we're going to go to Mark Lemley from Stanford, who's going to speak about law and equity and give us some takes from the Liu case, which Owen will also talk about, and ROMAG, which is a trademark case in the area. Again, both of those talks getting into disgorgement and restitution and some wonderful ideas. And then Pam Samuelson has been working on a really wonderful draft about the implications of eBay into copyright cases, and is it really having the effects that were feared and or celebrated. So mostly people have talked about the accidental revolution there, but we'll get to hear what she's seeing in those copyright cases. Then we'll have Chris Seaman, who's news from Washington and Lee, and he will talk about the scope of trade secret injunctions. And then last but certainly not least, our Call for Papers winner, Tracy Thomas, who is at Akron, and she will be talking about shadow docket remedies, which really couldn't be continue to be more timely. So with that, we're going to go ahead straight to Owen O'Dell. I am going to mute, and we'll be here watching your chat. And we know the audience, even though we're disconnected, we're connected in spirit, and we'll be watching to see what you have to say. So feel free to keep that chat going. Thanks. Owen.
Okay, unmuting. That would help. Hi. Good evening, Irish time. My name is Owen O'Dell. I'm a professor of law at Trinity College Dublin, and I'm delighted to be here, even if remotely. I was thrilled to be invited by Caprice, and I'm grateful to Caprice and John for providing this opportunity. I've been working on restitution for a very long time. It's one of the things that I do. Intellectual property is another, so I'm looking forward to everybody else as well. So this session suits me absolutely perfectly. And it turned out, as I was putting this presentation together, that the two topics of the conference and of the session gelled together. So the subtitle, The Power of Words and Remedies in Uncertain Times in the Law of Restitution for Unjust Enrichment, is disgorgement a word of uncertain meaning? And so you've got the question of the power of words, you've got the question of uncertainty, all coming into disgorgement. And that's what I'm going to talk about. And I'm going to do so in the context of Liu versus the Securities and Exchange Commission. And I don't think I'm going to spend a great deal of time on the background. Liu is a fraudster. The SEC wanted to remove all of the profits that he had made from the fraud. The relevant legislation allows the SEC to seek equitable relief, and the question was whether disgorgement came within this phrase. Now, we have two previous decisions to help guide the Supreme Court on this question, Mertens and Hewitt. It's an ERISA case rather than an SEC case, but basically it turns on what appropriate equitable relief means, because ERISA permits a claim for appropriate equitable relief to redress violations. And Justice Scalia said that in the context of ERISA, in Mertens, appropriate equitable relief means only those types of relief typically available in equity, such as injunction, mandamus, and restitution, and excluded in that case common law tort compensatory damages. Now, I will stop to say that mandamus is not an equitable remedy in the Commonwealth outside of the United States. It's a stateside order available in public law. It would be a mandatory injunction in private law, but I understand what he means. And I'm going to say a bit more about whether restitution is a typically equitable remedy in a minute. And then in Great Westlife and Annuity, the same judge 10 years later said much the same thing and excluded contractual damages. So it's perfectly clear that anything that savors of common law does not come within those appropriate equitable reliefs. And so for the majority here in this case, Justice Kagan said very clearly that disgorgement was typically equitable and came within the SEC statute. Equity has long authorized courts to strip wrongdoers of their ill-gotten gains with lots of remedies. That may be true, but she's mushed a lot of stuff together. And then she said that it should be limited to net profits. I'm not going to say anything about that part of the holding. I'm going to focus on the first part of the holding. On the other hand, in dissent, on his own, Justice Thomas said that disgorgement is not a traditional equitable remedy. It's a 20th century invention. It's a word with no fixed meaning, hence my second half of my subtitle, and it undermines our entire system of equity. So, unusually, Justice Thomas told us what he actually thought about something. So I have two questions. From the outside looking in, from the international perspective, which I am interpreting as the common law world outside the United States. What is the relationship between equity and restitution for unjust enrichment, and what is the role of disgorgement within that? And the relationship between equity and restitution is complicated, a bit like the old Facebook status. And the early leading case that the restitution tradition tends to start with, I mean, it's sort of the pause graph of restitution, at least outside of the United States, is a case called Moses and McFarlane. It's a judgment of Lord Chief Justice Mansfield, a photograph of a painting of him around the time this judgment was delivered. I think it's a couple of years later, but I couldn't find one more contemporary. If the defendant be under an obligation from the ties of natural justice to refund, the law implies a debt and gives this action founded in the equity of the plaintiff's case. So the ties of natural justice, the equity of the plaintiff's case, it's an equitable action which arises ex aequo bono. It's in respect of money which ought not in justice to be kept. The defendant in these circumstances is obliged by the ties of natural justice and equity to refund the money. So in the original leading case, there's a great deal of commentary about equity and about the equitable underpinning of restitution. On the other hand, it was an action for a subset. It was an action for debt. That is a common law action, not an equitable action. And the examples of where justice requires repayment, mistake, consideration, imposition, or duress, were common law actions for money had and received. So one strand says that all of the equitable stuff is simply window dressing or obiter, and that the real point is that an enrichment is unjust if you've got a mistake or a consideration or an imposition. But there's a spectrum of views throughout the 19th century in particular. Some judges focused on the equity stuff and said that's a good idea. Some judges focused on the equity stuff and said that's a terrible idea. It's well-meaning sloppiness of thought, but ought to be ignored. And the modern tradition draws on both strands. In Canada, for example, in a case called Petkus versus Becker, and this is Rosa Becker on the left, the ultimately successful plaintiff, Mr. Justice Dixon on the right, equated unjust enrichment and the constructive trust because of the equitable language of Lord Mansfield and Moses and McFarlane. And more recently, Justice Cote had to say, well, yes, there is the equitable stuff, but there's also the common law personal stuff as well. And in Australia, okay, so to lawyers, the guy on the right is the important guy in this photograph. He was Chief Justice Murray. To everybody else, the guy on the left is the important person in this photograph. He's Murray's son-in-law, also known as Eric Bana, the actor. And in fire construction, Murray for the court disparaged the capacity of unjust enrichment to distort equitable doctrines. So at one end, you've got equity is a good thing, let's merge it with restitution, that's Canada. You've got at the other end, equity is a good thing, let's not distort it by restitution, that's Australia. And just a little bit of some Irish stuff for the purposes of the talk. The guy on the left is Chief Justice Keane. He's the second last Chief Justice. The guy on the right is Chief Justice Keane. The building on the left is the Bricklayers Hall, the very first of that row of buildings. And it was built in the early 1800s and completed in 1812. And the front was nicely finished by the Bricklayers Guild. And that property was purchased by the Dublin Corporation to widen the road, subject to a charge, subject to a payment by the corporation to allow the front of the hall to be reinstated on the remainder of the hall after the road was widened. And then they didn't do that, and the corporation sought the money back. And Chief Justice Keane gave the leading restitution judgment in Irish law, where he said, the law is avoiding pantry justice and recourse to equity and discretion. by focusing on causes of action like duress or mistake or failure of consideration. So he took the common law tradition from Moses and Macfarlane, not the equitable tradition from Moses and Macfarlane. That's what it looks like now, that office building on the left, and that's about to be demolished and replaced by that office building by next year. Anyway, the Irish position is the same as the UK position. Andrew Burrows, who had previously been a professor of law in All Souls College, Oxford, and is now on the UK Supreme Court in Sansadur, said pretty much the same thing. To be honest, in fact, he is drawing on his own academic writings, and Judge Keane was drawing on Burrows' academic writings when he was an academic to say the same thing. So the UK and Ireland see the distinction between the common law and equity and have largely taken the common law route, whereas the Canadians are taking the equitable route. And to be honest, that's what the US courts are doing too, largely ahistorically. If we had an interactive chat here, I'd be asking, who are these, and wondering whether anybody would recognize them, but instead I'm just going to give the game away and say that on the left is Warren A. Seavey and on the right is Austin W. Scott. And so you now know where I'm going with this. They were the authors of the first restatement, and the subtitle specifically recognizes that there's common law stuff and equitable stuff when it comes to restitution. Quasi-contracts are the common law claims like mistake, duress, and failure of consideration, and constructive trusts are the main equitable claims, though not the only ones. And the current restatement, that's Andrew Cole, the third restatement, equally recognizes this difference between the common law and equity. But the judicial usage doesn't tend to do that. If we go back to Liu, if appropriate equitable relief excludes common law damages claims and in tort and contract, and if restitution claims are in the first instance common law and not equitable, then it should follow that appropriate equitable relief excludes restitution claims. And it means, God forgive me, that I'm agreeing with Justice Thomas. Disgorgement. This will be quick. My wife, who is the champagne expert in our house, tells me that disgorgement is part of the process of bottling champagne, but I tell her that it's actually something else. And this for everything that I'm about to say about Kansas and Nebraska, if it makes sense, I've stolen it from Caprice. And if it doesn't make sense, it means that I'm not understanding what she's been saying. But this is a case in which the Supreme Court had to look at effectively profit by breach of contract, though it's a special contract, a compact between the states. Even so, Justice Kagan told us that the proceedings were basically equitable in nature, and there's a great deal of flexibility inherent in equitable remedies. So disgorgement, vaguely equitable. Okay, so the same sort of language as in lieu, we simply have an assertion that the claim here is going to be equitable. Dissenting, Mr. Justice Thomas, applies ordinary contract principles, many of which he nicked from Caprice's work. Disgorgement is not available for a non-deliberate breach of contract. There is actually authority outside of the US to say that it can be in certain circumstances, and that's in Caprice's work, that's in the Restatement Third. And even if it were, such an award must be based on Nebraska's profits, not a number that the master selected just sort of out of nowhere. Again, you've got the two strands here, the common law stuff and the equitable stuff, and it's the equitable stuff that seems to be prevailing. So if we look at the language that is used in various other cases, on the left here is George Blake, a notorious British spy who died in Moscow last week at the age of 90 or so, and on the right is Lord Nichols, who gave a judgment in a case in which the Attorney General sued Blake in a SNEP-like claim, and they talked about account of profits, restitution, restitutionary damages, and disgorgement interchangeably. SNEP, no hint of the word disgorgement. Later, Morris Garner narrows Blake, barely mentions disgorgement. Back to the Australian case, Again, not really thinking in terms of restitution or disgorgement for these equitable claims. And this is the new Chief Justice in Australia. Well, she's now the outgoing, but the successor to Murray, that's Susan Kiefel. And again, disgorgement is prophylactic rather than restitutionary. My point is this: disgorgement as a word is really a product of two significant academic developments. Alan Farnsworth's 1985 article, it's not the first time that disgorgement is used, but it's the first time that it becomes a significant part of the analysis, a driver of the analysis, a title of the analysis. And that's in the context, the contract context, the Nebraska context, the Blake context. Then in the early 90s, there's some academic work, and the leading is by a Canadian academic called Lionel Smith, where disgorgement is taken from the Farnsworth contract context and moved into a restitutionary equitable situation. Most of the cases that use disgorgement in the way in which it is used in lieu outside of the United States start in 1990. And so it is this academic work that has created it. And if you want to know what it means now, at least on the academic side, I refer you to Caprice. But my point again is this: in lieu, if appropriate equitable relief is the relief typically available in equity, and if disgorgement is a recent and unstable academic coinage, then appropriate equitable relief excludes disgorgement claims. Again, from the outside looking in, I'm agreeing with Mr. Justice Thomas. Oh dear. Thank you very much.
Thank you so much, Owen, for that wonderful both insights and catching everyone up who and perhaps isn't as knowledgeable about all the different cases that have come through, but giving us that wonderful international perspective and trying to keep the U.S. Supreme Court into some consistency, which hasn't been the case for those issues. But let's get straight to it. And we're now up with Mark Lemley, who's going to continue to tell us a bit about and perhaps give us a little more background on lieu and then ROMAG and what are sort of the law and equity divides there and how do we make sense of it.
Right. So our sudden last minute switch in order actually turns out to be propitious because I'm going to start sort of with Lou where the last speaker ended. He suggested that he was troubled to find himself aligned with Justice Thomas. I want to suggest that he is right to be troubled by that fact because he's almost certainly on the wrong side in the Lou case. In the Supreme Court has three major cases in the last 2 years on disgorgement and the role of equity in a statutory world. Those cases point in fundamentally different directions. I think they've got lessons not just for remedies, but also for the role of history and plain meaning in Supreme Court jurisprudence. So you've heard a bit about Lou, some of the background. So this is not a contract or a tort case. This is a securities fraud action. The Supreme Court several years before had concluded in the Kokesh case that disgorgement as a remedy by the Securities and Exchange Commission was a penalty for procedural purposes. And it then confronted the question, well, equity doesn't usually allow penalties. It's not traditionally the province of equity to penalize. So is disgorgement actually a proper form of equitable relief, given that limitation in Kokesh? In lieu, Justice Sotomayor, for the majority, I think quite sensibly walked through the history and suggested that disgorgement as a unifying principle is in fact a time-honored equitable remedy. And here I have to disagree with my learned colleague. Justice Thomas seems to suggest in his dissent, well, the word disgorgement is of relatively recent vintage as an effort to unify various parts of the principles of equity. And therefore, because we didn't use the word disgorgement in these terms historically, it must not be an historical equitable remedy. But I think that's a mistake. I think that's a misunderstanding of the form and the term of the word for what it is that we have traditionally permitted. And what it is that we have traditionally permitted is not just the possibility of obtaining in contract at common law some forms of unjust enrichment. We've permitted a much broader form of unjust enrichment and restitution that's gone by multiple names, including accounting for profits and the like. And those principles of equity are in fact longstanding. And the concept of disgorgement as an equitable principle is an effort to try to bring those things together. So the court says that is a longstanding equitable principle. That is something equitable relief encompasses when you write it into the statute. That said, Justice Sotomayor says we do want to make sure that we are not, in fact, shading over into penalty. Right. In order for this to be a traditional equitable concept, it's got to actually be about disgorgement of ill-gotten gains, right, and not about an effort to penalize or deter. That line, frankly, has always been a little bit blurry in remedies law, right? The point of disgorgement of ill-gotten gains is, in some sense, to discourage wrongful acts. And there's a sense in which that's a penalty, but it is a line that we have long drawn in remedies. And the court says we're going to hew to that line in lieu. And to do that, the court says, well, what is it that prevents it from being just a punitive damage award of the kind that you would find in law and statute, not equity? First off, the money ought to go to the victims. And here the court says the SEC generally, when it gets a disgorgement remedy, tries to find the victims and recompensate them. There can't be joint and several liability without specific acts of joint wrongdoing. You can't be held liable merely because you are sort of in a relationship with someone who did something bad. Unless you were yourself a wrongdoer, you're not going to be held jointly and severally liable for disgorgement. And finally, there has to be apportionment of profits and a deduction of costs, at least unless the entire enterprise is wrongdoing. And I think this opinion is great and important. It shows awareness of the history and purpose of disgorgement and the history and purpose of equity. And I think it's careful to cabin disgorgement in a way that limits it to cases that deprive defendants of their ill-gotten gains. And I think Justice Thomas's dissent, frankly, by contrast, misunderstands and sort of narrows by a focus on did we use this exact term for this concept 200 years ago, misunderstands what the point of the history of equity is. Contrast that with a decision less than a year before from the Supreme Court in Romag versus Fossil. Justice Gorsuch's opinion here is, I think, frankly, a bit of an embarrassment in a couple of respects. So the background here is that trademark law allows an award of damages to the plaintiff. It also allows the recovery of defendants' profits under the statute, quote, in accordance with principles of equity, close quote. Now, those principles have always required conscious wrongdoing as a basis for disgorgement, and all circuits so held until the late 1990s. And in the late 1990s, Congress passed the dilution statute, and it expressly said you can't get any monetary remedies, damages or disgorgement of profits unless dilution is willful. Unfortunately, it made the mistake of putting that provision in the same subsection as the trademark damages provision, so that the trademark damages provision now said you can get profits, disgorgement of profits in accordance with principles of equity, and you can get damages and disgorgement of profits for willful acts of dilution. On the basis of that, some but not all circuits said, well, gosh, we read the statute and it says willful explicitly for dilution. It doesn't say willful explicitly for trademark infringement. So it must be the case that Congress intended to retroactively undo hundreds of years of jurisprudence and eliminate the willfulness requirement for disgorgement. Unfortunately, Justice Gorsuch's opinion for the court bought into that story. It is very heavily focused not on the history, but on what he views as the plain meaning of the statute. I think his plain meaning reading of the statute is simply wrong. It doesn't actually understand it. It certainly ignores the history of the way the statute was enacted and the fact that this was added as a remedies provision for an entirely separate provision of the trademark law and was not intended to modify it at all. But the court's opinion uses a sort of rogue form of expressio unius est exclusio alterius, right? You said willfulness expressly here. You hadn't said willfulness in the past expressly somewhere else, so willfulness must not be a requirement, and concludes that Congress must have meant to eliminate the requirement for conscious wrongdoing and for disgorgement. What does he do with the fact that the statute still requires that disgorgement be in accordance with principles of equity? Well, he says, I looked up the word principles in the dictionary, and we think principles is really more guidelines than actual rules. Principles just means kind of longstanding trans-substantive rules. There isn't a principle of no disgorgement without willfulness in trademark cases. That would be a specific rule rather than a trans-substantive rule. Now, there are a couple problems with that. The most fundamental problem with that is, right, the requirement that you be a conscious wrongdoer for disgorgement is, in fact, a longstanding trans-substantive rule of equity. It has been across all areas of law. Interestingly, Justice Gorsuch points to the one exception, which is patent law, which for a while allowed disgorgement without proof of conscious wrongdoing until Congress eliminated the disgorgement requirement entirely from patent law in 1946. So in the context of saying there must be a trans-substantive rule, Justice Gorsuch writes out of history that very trans-substantive rule, right? Saying, at least for trademark law, no requirement of conscious wrongdoing. Furthermore, he says, it wasn't an absolute rule of equity. How do we know it wasn't an absolute rule of equity even in trademark cases? Well, I kid you not, there's a district court in Alabama in 1883 that found disgorgement without conscious wrongdoing. And so clearly there wasn't a well-established principle, right? It's the cases were contested. Now, I suggest that if the idea that sort of equity to have a longstanding principle requires absolute unanimity of courts throughout all jurisdictions and all times, there is no absolute principle of equity anywhere. It seems pretty clear that the court has taken a concept that was a fundamental equitable concept, a limitation on disgorgement to conscious wrongdoing, written it out of the statute because of its willingness to ignore the history of equity in favor of its reading of the plain meaning. The court does concede that willfulness remains an important factor, so the practical impact of this in trademark cases might end up being relatively minimal. It's clearly going to do some mischief and embolden some bad cases, but maybe the courts will mostly reject them. 4 justices in 2 different concurrences basically said, you know what, all we're saying is it's not an absolute complete prerequisite, even though it's a really important factor. We're not signing on to the rest of this stuff, but we still have a majority that says, ignore the history, ignore the principles of equity in favor of our read of the plain meaning. And that's going to lead us to the cases we've got coming up this spring, the Federal Trade Commission cases. The court's going to hear argument this spring in 2 cases about whether the FTC has disgorgement authority at all. They have long had disgorgement authority. That authority has been confirmed in a number of cases, including prior Supreme Court cases. The problem is, though, that the statute says the FTC can obtain an injunction in district court proceedings. And whatever one thinks of the term equitable relief in SEC versus Liu, it is a further step. It's a harder ask to say that the term injunction includes the ability to order disgorgement in appropriate cases. I think historically that is the correct conclusion. And Caprice and I, among others, filed a scholar's brief talking about the various circumstances in which the power to order an injunction has come throughout history, with the power to order incidental relief in the form of disgorgement of profits and money damages in other circumstances. And the Supreme Court has previously allowed this in various comparable circumstances. But I worry that a plain meaning focus of the kind that Justice Gorsuch brought to Romeg versus Fossil is unlikely to be swayed by that history, particularly given the sort of troubling view of the history that Justice Thomas brought. So we've got to hear, I think, a growing split among the sort of right-wing majority of the Supreme Court between the plain meaning folks and the originalism/history folks. We see that split outside of remedies, right? We saw it in the gay rights case last year, right, where Justice Gorsuch signs on to his read of plain meaning of the statute and rejects the history there to sort of, I think, positive effect. But I think the FTC cases are gonna come down to whether or not we buy into the plain meaning as we read the term injunction today, divorced from history, or whether we look at the sort of history of what the injunctive power at equity has long been able to do. I fear, particularly given that some of the history advocates like Justice Thomas have a weird and cramped view of history of disgorgement, that the plain meaning view is likely to prevail and the FTC will end up hobbled. My personal view, frankly, on this broader debate is I kind of want to plague on both of their houses. I think neither sort of what did we do 250 years ago, nor what do I think without looking at any context this word means in isolation is the correct answer. But history, if we're to choose between those two, history at least has some consistency behind it, and equity is nothing if not history. So I have hopes for the FTC, but I think, frankly, the signs are not good for what the Supreme Court is likely to do for FTC disgorgement.
Thank you so much. Thank you so much, Mark. And we are running fairly on time, so we're going to keep everybody to their time. And we've got Pam Samuelson up next. Now that we've called for a plague on both houses, we're going to pivot, and that's always dangerous in the midst of a plague. We're going to pivot to Pam from Berkeley, and she's going to talk about the impact of eBay. And we had a great panel at AALS a few years ago about the extraordinary effect of the eBay opinion, or the anticipated effect. And so now she's going to tell us how it's happening in copyright cases, and we're going to hear from her, and then Chris, and then Tracy.
So, hello everyone. Sorry we can't be together, but I'm very pleased to be participating in this event. I'm not really a remedies scholar, but I've kind of gotten pulled into remedies because some of the really interesting things in the intellectual property space are actually happening on the remedies front. So like Mark, I've been very interested in the Romeg case, and I have a forthcoming article actually about disgorgement in IP cases coming out in the BU Law Review. And let me just say that Mark's interpretation, at least of the disgorgement in the context of IP, is one that I very much agree with. And I hope that if anyone's interested in the disgorgement stuff, that you will get in touch with me. I've been very fortunate to work with Mark Gergen, and more recently with Mark and with John Golden, because they know much more about remedies than I do. But I'm having fun, actually, doing this kind of work. Now, the kind of itch that got me started on eBay was really, I just wondered whether it had really had an impact. There was an article that was published in 2012 that suggested that actually eBay has had very little impact in the copyright context. And so I wanted to sort of see, well, have things changed? And my sense was maybe they had. So I realized that to the remedies scholars that eBay is kind of a bad case. Professor Laycock basically says, no one ever heard of this 4-factor test. Gergen, Golden, and Smith call it a judicial straitjacket. And Professor Rendelman says a judicial blunder, and Caprice Roberts, a move backwards. And I'm here to say, I really like eBay and what it's done, at least on the copyright side. So there. So there are kind of main things that it gets criticized for are that the irreparable injury and inadequate legal remedies are not two separate factors, but actually are two sides of the same coin. That's one of the criticisms. The disavowal of presumptions, which have long been part of equity in injunctive relief cases, was something that got criticized. No room for other kinds of equitable considerations, such as unclean hands and oppressive behavior, etc. And if you read it straight, it looks like they're 4 prongs, not a kind of balancing test. So those are the main criticisms. And I think that those criticisms may be sound, but I'm telling you, in the context of copyright, and I think also Mark Lemley would agree with me, in the context of patent law, eBay has had largely salutary effects. Now, as of mid-November, eBay has been cited more than 4,100 times. Its most substantial impact has been in the patent context, so that nearly a quarter of the patent infringement cases now are ones in which an injunction does not issue. Mark Lemley explored in a paper trademark injunctions, the effect of eBay on trademark law. The end of the year spending bill basically restored the presumption of irreparable harm in trademark cases. So one of the things that Mark was worried about, I think, is taken care of through that recent legislation. But the 2012 study by Professor Liu reported very little impact. So very few cases had actually, so through 2010, very few cases actually had cited eBay at all. And those that had cited it and recited its factors did so in a very cursory fashion. I'm going to say that was before 2 appellate court decisions, one in the Second Circuit and one in the Ninth Circuit. And the Ninth and Second Circuits are in copyright land, the 2 most important and influential circuits. And once in the Salinger case, and in the flexible case in the Ninth Circuit, decided that eBay actually had to be taken seriously and reversed cases in which injunctions had issued without going through the 4 factors. Things have indeed changed. So my paper actually groups the withholding injunction cases in 3 clusters. I note that in the sort of prior to 1994, if you showed actual infringement or likelihood of success on the merits, you almost automatically got an injunction, except when there was unreasonable delay. But things started to change, or at least I thought they started to change in 1994 with the Supreme Court's decision in Campbell versus Acuff Rose. That was a case in which the court decided that the 2 Live Crews rap parody of Pretty Woman was actually likely a fair use. And one of the things that it said in a footnote was that in close fair use cases, courts can consider not issuing an injunction if there is actually a public interest in access to the infringing work. So that dictum in Campbell, I was interested to see, has it really had an impact? And the answer to that is no, except in two situations. So there's a case in which Alice Randall wrote wrote the story of Gone with the Wind from the slave's perspective. That was a case in which a lot of characters and dialogue had been appropriated, but the 11th Circuit basically said strong fair use defense can answer damages if there is ultimately deemed infringement. So that's a case in which that footnote was actually really important. The only other place that it's really been important is that eBay relied on it. eBay relied on a copyright case saying you don't have to issue injunctions. And there was also dicta in the Tassini case in 2001, also saying you don't have to issue an injunction. Again, the Supreme Court relying on its own precedents to basically, but its copyright precedents to basically say that injunctions don't have to issue in patent cases either. So there's an interesting thing of copyright cases basically affecting patent cases, and then more recently back to copyright. But since 2010, there are many fewer injunctions are issuing. I've got a separate empirical project with Matt Sag, which is going to document that since 2010, the injunctive relief is less common in copyright cases, and I think that there's some common fact patterns to cases in which the courts have withheld injunctions post eBay. So if the plaintiffs don't even try to say what the irreparable harm is, they're not going to get an injunction. And litigants have been in a contractual relationship that went sour. Those cases often also result in no injunction issuing. Other kinds of bitter feuds between people often end up not resulting in injunctive relief. Also common, but not as common as the other three that I just mentioned, are cases in which the infringing part is a small part of a much bigger non-infringing work, so that the courts basically say, well, damages will suffice. Also, very common in the post-eBay cases now have been concerns about not just harms to the defendant, but also the effect of an injunction on third parties. And so if the third party is going to be harmed by an injunction, courts have been taking that into account, and where the injury that the plaintiff is complaining about is not a copyright injury, courts have been withholding injunctions in those cases too. So just to sum up my conclusions, overall, eBay has had salutary effects in the context of copyright cases. Injunctions are common in simple piracy cases, but I think what we can see from the case law is that the presumption of irreparable harm prior to eBay was too hard. It was like the categorical rule that the Federal Circuit had adopted that caused the Supreme Court to reverse it in the eBay case. One of the things that that now putting a burden on plaintiffs to say what the irreparable harm is that courts actually have to explain, right? Before, when it's a presumption of irreparable harm, I don't have to articulate what it is. So now actually there's a refined jurisprudence about what irreparable harm means in the context of copyright. And I think that's actually a good thing. It's also the case that notwithstanding the Winter case, which collapsed irreparable harm and inadequate legal remedy, the copyright case law is still paying attention. Was there irreparable harm separate from are damages adequate? And more cases are actually deciding that damages are adequate than in the past. So I think those things are really quite interesting. And the other thing is that so I think that's actually been a good thing. And courts are taking traditional equitable remedies or other considerations into account. So if somebody is being vindictive and being oppressive, courts will withhold injunctions. Sometimes if the defendant is with innocent infringer, then also no injunction will issue. Public interest is one of the few factors, though, that explains very few of the cases. So that's actually what I wanted to say. Thank you.
Thank you so much, Pam. And I've always said this section is one of the most collegial, and we also do try to pull people in. So beware of those of you that are out there that are not Remedies section members. We love to have people from all different areas because that's what Remedies does. As Pam mentioned, not everyone is in agreement about, even though a lot of Remedies professors critique eBay, not everyone agrees with that, and Tracy put some of that in the chat. We'll keep talking. And next up, we have Chris Seaman, who will talk about the scope of trade secret injunctions. So we'll stay with the theme, and then we'll last have Tracy.
Thanks, Caprice. It's really a pleasure to be part of this panel. It's a difficult order to follow. Owen and then Mark and now Pam on this, but I think it's going to be an interesting talk. And I'd like to add my congratulations to my colleague, Doug Rendelman, who has been a terrific mentor and colleague. He's really the exemplar in my mind of an outstanding scholar who's continued to be incredibly impactful and prolific through decades. So just wanted to sort of echo my congratulations to Doug on a terrific career and a very fitting award. So my talk today is about about trade secret injunctions. I'm going to go ahead and throw up a slide deck here. All right, I think everybody can see that now. Okay, all right, good. So I've previously written a few articles about injunctive relief in patent cases. I have also talked and written some articles about the Defend Trade Secrets Act passed by Congress in 2016. So I decided it was finally time to come to put the two together and to write a piece on trade secret injunctions. And surprisingly, there's really not much in the literature over the last 10 years or so. The only pieces I'm aware of is Elizabeth Rowe's recent qualitative empirical study and W&L's own law review about trends in injunctive relief in trade secret cases. Deepa Varadajan has a really good piece on eBay and trade secrets. And then about a decade or so, Richard Dole wrote a piece on the duration of trade secret injunctions under the UTSA. But there's a lot of unanswered questions, particularly about the scope of injunctive relief. And I was also partly inspired by John's own article on in the Texas Law Review about the scope of patent injunctions, where he talks about injunctions not simply being an on or off switch, right? That they're tailored in scope. And so that kind of got me thinking about this particular project. So a quick rundown for those of you who aren't familiar with trade secrecy, sometimes called the redheaded stepchild of the intellectual property law world. What is a trade secret? It's pretty straightforward under the UTSA. The information that derives value from not being generally known or readily ascertainable using legitimate means like reverse engineering or independent discovery, and is it subject to reasonable efforts to maintain its secrecy. So this is really broad in scope. It can include everything from manufacturing processes, customer lists, algorithms, and secret formulas and the like. And unlike patents, there's no agency out there that tells you have a trade secret. Instead, it simply exists if you meet the legal criteria. So what is misappropriation? There's a couple different formulations of what qualifies as misappropriation: acquisition by so-called improper means, or disclosure or use of the trade secret without the express or implied consent of a person who improperly acquired it or knew or had reason to know it was derived from a person who was under a duty of confidentiality regarding the information. And so these improper means can be everything from outright theft, bribery, hacking, or electronic espionage. But the most common scenario, based upon empirical work from others, and as well my recent piece with Dave Levine on the first year of the Defend Trade Secrets Act, the most common scenario was a so-called faithless employee, an employee who learns information while performing their job. They then leave the job and then improperly or disclose or use that information in their new position. So it's a little bit less dramatic maybe than some of these pictures suggest. Trade secret litigation right now is a bit of a growth industry. You can see a chart here from Lex Machina over the last 10 years. We've seen about a 30% increase in trade secret litigation in court since the beginning of the decade. And the reason for that bump largely appears to be the passage of the Trade Secrets Act in 2016. There's a picture from the signing ceremony. It's actually kind of remarkable. It's one of the few pieces of bipartisan legislation that passed overwhelmingly on both sides. And so I'll talk about both the UTSA and the DTSA to the extent that there's anything to say about the scope of injunctive relief in my talk. And I should note, I guess I'll note about the DTSA's remedy provision in just a second here. So let me talk about injunctive relief in trade secret cases. In many ways, in fact, it's the whole ballgame when it comes to trade secrets. And the reason why is if the trade secret gets widely disclosed or publicly accessible, like posted on the internet, protection is lost. And so one of the things that a trade secret owner often wants to do upon discovering that a secret has been misappropriated is to get relief as quickly as possible to prevent further dissemination of that trade secret. And that often takes the guise of a temporary restraining order and or a preliminary injunction request. So what is the UTSA's language here? Again, this has been adopted with some modifications in 48 different states. And so there's quite a bit of case law on UTSA's injunction provisions. Subsection A deals with injunctions for actual or threatened misappropriation. It also provides that the injunction terminates when the trade secret no longer exists, but it may be continued for what's called the so-called head start or lead time injunction to prevent the misappropriator from improperly benefiting from access to information. So if it gave somebody a 6-month head start, for example, on their competitors by learning the trade secret information, even once that information becomes public and others can use it, that the misappropriator will be subject to another 6 months of the injunction. Subsection B deals with a so-called royalty injunction that under exceptional circumstances, an injunction may be conditioned upon a future payment for use of the trade secret information. This has echoes in the remedies world, obviously, of the famous Boomer versus Atlantic Cement case for a nuisance injunction where you can buy your way out of it by paying the complaining parties. And there's a variety of reasons the UTSA might do that, including so-called innocent acquirer of trade secret information who materially changes his or her position without knowing the information from the trade secret when they first get it, and if there's some overriding public interest or impact upon third parties of imposing an injunction on the misappropriator. And then third, I'll talk a little more about this when I go to the scope, is to be clear that that injunctions aren't merely prohibitory, they can also be mandatory in the trade secret context. The court can order the misappropriators to take certain actions to protect the trade secret owner's rights. Okay, DTSA, again, it's language here. A couple of things to note is that the DTSA included some language that precludes the entrance of an injunction against a person from accepting a new employment based solely upon the trade secret information that he or she knows. And also it precludes an injunction that would otherwise conflict with state law prohibiting restrictive covenants on employment, most notably California's prohibition on non-competes in most cases. These were actually added during the legislative process based upon a number of objections that have been raised. So let me go on quickly to talk about the different types of injunctive relief in trade secret cases. Obviously, I mentioned preliminary injunction, and this is somewhat unlike patent law, where an injunction is very important at the permanent injunction stage at the end of litigation. In trade secret cases, this is often one of the big focuses is getting quick injunctive relief against the misappropriators to prevent further harm to the trade secret owner. So it's governed obviously by Rule 65A. The purpose is to maintain the status quo during litigation. And again, as I mentioned, often it can be outcome determinative effectively. If the court enters a preliminary injunction, in many cases, the parties will then end up settling the trade secret dispute out of court. And again, the courts apply the well-known winner factors, demonstrating likelihood of success, likelihood of irreparable harm absent a PI, balance of equities, and that it wouldn't harm the public interest. Permanent injunction, obviously, the end once the liability is found. Interestingly, many but not all courts apply the eBay factors on this. This is one of the things I'm considering looking at in a more detailed empirical study about the reliance upon eBay when it comes to trade secret cases. But interestingly, there's also a split in the lower federal courts about the presumption of irreparable harm in trade secret cases post-eBay. A number of them have, including an unpublished case, the Federal Circuit, have pointed to the nature of trade secrets that if they're disclosed, that effectively destroys the trade secret holder's rights in them, that creates a presumption of irreparable harm. Other courts, including the 10th Circuit, have said no, that eBay meant what it said, includes and it applies to trade secrets as well as patents, and that the owner must prove irreparable harm. Okay, so going beyond the requirements, right, the scope of injunctive relief, I like this quote from the 7th Circuit, that being clear that injunctive relief must be tailored to the facts of the case and only as broad as necessary to protect the trade secret holder's rights. The concern is that an overbroad injunction could negatively affect competition from others. Okay. So content of injunctions, Rule 65D does talk about that that the court must state the reasons why the injunction is issued, its terms specifically, and to describe in reasonable detail the acts restrained or required. Quickly gonna go to what I call the four W's. Those of you who've done journalism know you have the 5 W's: the who, the what, the where, the when. I'll leave out the why. That's the court's explanation for the reasoning. But when it comes to scope, what I'm gonna briefly talk about are the issues that come up. One is what conduct is prohibited or required by the court. Second, who is bound by the injunction, and in addition to the parties, if any. What is the geographic scope or limits of injunctive relief? And then finally, the thorny question of when does the injunction terminate? Okay. All right, so talking about acts restrained or required, I mentioned two different types of relief. One is prohibitory injunctions. The two most common are what's called a disclosure injunction and a use injunction. Most injunctions include both of these requirements, that they misappropriate or not disseminate the information any further and not use it in their business. But there's also a number of mandatory steps that a court can and has ordered in a variety of circumstances, including the return, the destruction, or deletion of trade secret information and documents or other electronic media, recall of products made with the trade secret information, steps to protect against further disclosure, like requiring encryption, password protection of any servers that might have trade secret information on it. And then particularly the preliminary injunction stage requirement that the alleged misappropriator mirror the servers or other media that may have the trade secret information to determine the scope of what trade secrets may have been misappropriated and who may have had access to them. And finally, requiring a certification to the court about those steps have been completed to make sure that they're complying with the injunction. One question is the specificity of the injunction. What does it require in terms of trade secrets? And so generally speaking, you must identify the trade secrets in the injunction. But often
you've got about 1 minute. I want to make sure that we get Tracy in too. So I hate to.
I did see that, Caprice. I'm going to go quickly through the rest of this. Right, generally, but you don't want to have it be self-defeating by saying, hey, look, here's what the court publicly disclosed, being all the trade secret information. So one way to handle that is to put the trade secret information in the appendix or another order itself. There's mixed authority about whether injunctions can extend to disclosure use of a formula that's substantially similar to trade secrets. Kind of an interesting area I'm still poking around about. Who is bound? Generally, the parties, officers, any others who are acting in concert or participation with the trade secret owners. And there have been some interesting cases about whether, for example, parties who purchased a company out of bankruptcy would qualify for that. I'll just finish up a couple last things here. Geographic scope. Most trade secret injunctions are unlimited in geographic scope. The main exception tends to be if it's based upon a restrictive covenant like a non-compete that does have a geographic limit. Courts typically will not go beyond that. And then finally, the duration question is particularly thorny. Unlike a patent where we know where the end is, just so we know where the end of this talk is, some courts historically had what was called a perpetual injunction. They entered it and then required the trade secret, the misappropriator, to come back and say, hey, look, this information is no longer trade secret. Please release this from the injunction. The approach under the UTSA is the so-called Winston research, which creates a fixed duration for the injunction based upon the estimated time for independent invention or reverse engineering of the trade secret. That's largely what the UTSA has adopted. And then finally, I will skip whether I'm going to do empirical research on this in this paper or another. I would like to do that, and now I'm going to wrap up. So thanks, and apologies for going about 30 seconds over there.
That's okay. Thank you so much, Chris. And last but not least, our Call for Papers winner, Tracy Thomas. I want to get her in, and hopefully we'll be able to get to a couple of the questions, but we are chock full with all kinds of exciting things. So, Tracy.
All right, thank you. As you can see, remedies issues these days tend to be coming up in IP cases. So a lot of us in remedies are really watching IP because that's where some of the new cases are at the Supreme Court level. But before that, most of our key cases came in a lot of the constitutional law cases, kind of our core teaching cases. So my focus today is on what's known as been called the shadow docket. So the shadow docket is the U.S. Supreme Court's decisions that it does mostly on stays or procedural motions where it's making law, but we're not seeing how it's being made. It's being done in the shadows rather than out in the light. These are usually emergency petitions to vacate an injunction or to stay an order, to change an injunction that was issued below. The process doesn't have full briefing. It doesn't have full argument. It doesn't have amicus. It very rarely gets decisions. We might get a couple paragraph dissent or concurrence. And so there's real concern is that this interim relief is really, it's meant to just delay the case. It's not meant to create precedent, but it is creating precedent. And so these interim shadow cases are becoming merits decisions without really the rule of law. And others have identified some of the key problems here, the lack of transparency, maybe it's masking pure partisanship, again, that it's operating as precedent, that it's violating due process, our access to the courts. It's raising the legitimacy of the courts itself and the rule of law. And Justice Sotomayor, in an opinion pre-COVID, really tried to, really raised all of these concerns, is really challenging this process. And it's not just a technical issue, right? How do we get a stay procedure? Because these cases are high stakes. These are elections, presidential elections, state elections, COVID, life and death, constitutional rights of religion and voting. I mean, these are big, high stakes cases. So several commentators in the last few months have been trying to figure out what's really going on, right? Can we try to figure out the mystery here? Some have suggested that it's just pure partisanship. This is just masking political decisions. Some have suggested it's anti-democracy, sort of anti-courts. We want the democratic arms of government to make these kinds of decisions, so it's anti-judicial change. Or that it's just really on the merits. These are just a quicker way to get some of the merits decisions that the court would otherwise do. My thought was that maybe this is really about remedies, since it's about stays and injunctions, and that's really the heart of remedies. And maybe it could be explained by some key principles. And this is a pretty early work. It's really a work in progress. There's new cases almost every day, new thinking every day. So it's still a fast moving conclusion. But I'm focusing on the shadow docket cases of the last maybe 7 months, the COVID cases. And those are really two kinds. Those are from the election cases, so absentee ballot cases, changing witness requirements, initiative cases, curbside voting, and church cases. COVID restrictions on worship attendance limitations have been some of the key ones that have come about in this shadow docket. Before that, what was happening during the Trump administration were immigration policy, some death penalty cases, all of those cases brought by the federal government. So others have documented that before the Trump administration, we had 4 of these shadow docket cases. In the last 4 years, we've had 35. 22 were taken up by the court, all by the federal government, all won by the federal government. Obviously, in the COVID cases, we're talking about state government now. So we're talking about a slightly different actor, wondering what's looking for. And so my thought was that maybe 3 key remedies principles are driving these cases. 1, the goal of the status quo. 2, that it's simply the regular balancing test that we've been hearing about of eBay and Winter. Or that it's deference to the government, that horizontal and vertical federalism that we focus on when we think about public law injunctions as being a key policy behind those. So first, look at the status quo, right? The rule of preliminary relief, the goal, the ideal of preliminary relief is to maintain the status quo, freeze the dispute until the court can hear the full case, and we're supposed to do the least harm by not changing anything until we're sure the merits require that. In Winter, that was Justice Roberts, in a relatively recent case, came back to articulate that as the key goal. The stay, a procedural motion like this, is preliminary relief. The court adopted this essentially status quo in election context in something that people call the Purcell rule. A lot of in the news about this. 2006, another shadow docket case. Purcell versus Gonzalez, halting a new photo ID requirement for voting in San Francisco. Lower court, the Supreme Court says lower federal courts may not alter election rules too close to elections. And against the shadow docket, so we don't have much explanation, but basically to avoid imposing additional burdens, to not put barriers to the right of voting, and to protect the right of voting. The idea was to freeze the status quo. What were the voting requirements before this new change, a more onerous requirement of photo ID, and to maintain the pre-dispute status quo. So some people think this makes a lot of sense, right? This is the core Remedies black letter law. It seems to be nonpartisan. It should apply equally across the board. And maybe this should be it. So does it explain these COVID cases? Sometimes, about half so far, a little over half. In the election cases, it's explained 6 out of 7 that I'm tracking so far. In the church cases, it has not. Now, we have the recent New York City case versus Cuomo, which is not a shadow docket case, but it may give us a little insight to what the merits is going on. But anyway, so maybe it's the status quo, but the status quo is a problematic standard because it can be manipulated. What's the status quo? Free voting or voting changes, right? I mean, when we have a dispute, then each side can argue that the status quo is in their favor. More importantly, when you have an emergency like COVID and public health threats, the status quo actually continues the harm, right? The denial of voting actually continues the harm. We would never say that in domestic violence, right? Let's stay the action and let the domestic violence happen, right? So it doesn't fit emergency cases. It fits regular cases. So maybe this is just the balancing test. And in some of these cases, especially Roberts and Sotomayor, have cited the 4-part test, have focused on the factors, have weighed them. In particular, they seem to focus on the magnitude, the irreparability of the harm. What kind of harm is at issue? Whether it's sort of the factual harm, COVID, health, death, public health issues, whether it's the magnitude of the right, the First Amendment right to religion, the First Amendment right to vote. Of course, politically, there's a split on which one of those is important, right? Only the conservatives don't have the same value, have not protected the right to vote in the same way, even though they are saying that the constitutional rights should not change during the pandemic. Finally, let's come back to this idea of deference to government. This is clearly driving Justice Roberts and once or twice driving Justice Kavanaugh, right? So that there's let the government is the arm that needs to craft the solution here. So if the government is the one who has made the change to the voting, it's upheld. If it's the court trying to change the government, it's been rejected. If it's the government trying to limit worship services, that's okay. In other words, a deference. But that only explains Roberts. Now, he has been the swing vote until Amy Coney Barrett. Now we are seeing, at least in the one case, that it seems to be the rest of the justices may not be buying into that. So I don't have an answer so far, but I have some ideas and keep following these and some of the newer, I assume we're going to be getting some more of these cases and to see which one of these may track. I'll stop there.
Thank you so much, Tracy. And we originally had planned, of course, for questions from the chat, and we received a few great ones. And I know John has prepared some as well. So I don't know if anyone wants to meet up in one of the, surreal coffee breakout rooms. Our speakers would, some of them might be willing to do that if anyone wants to catch up there. John, I don't know if you wanted to say a word or two. You're welcome to. He's going to decline that invitation. All right. Well, I just want to thank everyone on the panel. It's also been wonderful to serve as the chair, and I'm glad to be stepping down and handing over the reins to Sam Bray. And I want to welcome everybody who's new to the section or wants to be new to the section. Remedies is a great area, tons of opportunities for growth and learning and scholarship. So thanks so much to our panelists. It was really an incredible experience to get to hear all of you together in your areas of expertise and while you're still developing too. Wonderful. Thank you so much.